So we've all seen, TV shows where there's a courtroom drama and an attorney jumps up after another attorney makes a statement. They say objection, and you wait for the judge to render their response. The two options there are objection overruled, objection sustained. Maybe the judge will call the parties up to discuss it a little bit. So what does objection sustained mean? That means the judge agrees with the person making the objection. They agree with the attorney who stood up and called out objection. They're calling out the other attorneys, saying that there's a reason that this question or that this testimony shouldn't be admissible as evidence. And the judge is saying, yes, I agree with you. The flip side of that is overruled. The judge makes a quick decision where they say, I don't agree with this objection. I think that it doesn't have a basis in law here. And then the line of questioning is allowed to proceed. The important takeaway here is that it requires a competent attorney, somebody who's experienced, to know how to make those objections, what the legal basis of them should be, and to quickly react in the moment and say, but before testimony comes out that could tarnish the jurors in some way or have them hear something that they shouldn't hear. So there's a lot of quick reflexes that happen in a trial where attorneys have to be paying very close attention to what's being said, what's being asked, so they can get out in front of something before it gets to the jurors' ears. So having a firm basis, a firm understanding of your grounds for your objections is very important, and when to actually deploy that as a weapon in your trial in order to effectively represent your client and make sure that the testimony that's being presented is presented fairly. But there's often bills that need to be paid, medical expenses, things that have accumulated, and clients need to take care of their responsibilities. So they're really looking forward to getting that check. How long does that take? I think in our experience, I'd say it's usually about 2 to 4 weeks, maybe a little bit longer. That depends on certain factors. Are there liens that we need to continue to negotiate? Medical bills that we try to see if we can get any reductions on? Sometimes that's possible, sometimes it's not. But we'll work as best as we can to make sure that we're getting our clients what's fair. So there may be some post-settlement negotiation that needs to happen, but I like to think, very efficient. So if there's anything that we can do in order to help facilitate resolving any outstanding liens so we can distribute the money once it comes in, then we'll do that quickly. I can't speak for how long it takes an insurance company or a defendant to prepare a check and mail it to us. Usually it seems like it's about 2 weeks, but there are instances where it can take months, and we've had to fight those issues in court where we've had to say, we've settled this case. We're filing a motion to enforce this settlement or enforce this judgment, whatever it might be, in order to hold the opposing party accountable and say, look, we came to an agreement. It's time you need to pay. That can be frustrating, but it does happen, I think, infrequently. But if you settle a case with our firm, I would anticipate that we would have everything resolved for you in as little as 2 weeks, and probably at the long end out to about 4 to 6 weeks.